Good evening, everyone. Welcome to one more webinar by Petition group members. This time it's an interesting topic for everyone, for every concerned citizen, every activist, where we find, irregularities, uh, corruption, non-implementation of laws, abuse of power. All this happens regularly by these people in power, mainly the public servants and the public representatives. So today the topic is how to prosecute these public servants who don't adhere to the law, who indulge in some mischief or the other for their vested interests, for their selfish gains. So we have with us Advocate Dilip Dhumaskar with us. He has been an old colleague with us now quite since several years. He has been with us guiding our members. And today he's going to speak upon how to prosecute public servants. As you all may have noted that, it's difficult to have these public servants prosecuted, penalized for what their mischief that they do. There are some hurdles created deliberately or otherwise by these government authorities so that their colleagues get protected. But nonetheless, we also have to be, knowledgeable about the law so that we can, take these people to task and get them penalized for the wrong things that they do. So we have with us Advocate Dhumaskarji, who has been he's a retired chief judicial magistrate and practicing advocate now. And I hand over the mic to him. Advocate Dhumaskarji, please start the webinar, please.
Good evening, everybody. Thank you, Oraji, for giving me this opportunity. Thank you, each and every member of the petition group, for giving me this opportunity to speak on this topic. Today's topic is prosecution of government servants. Basically, the prosecution job is done by the state government through the prosecutors. The accountability of the civil servants to the public is mandated under the Constitution. Article 53 of the Constitution provides that the executive power of the Union shall rest in the President and shall be exercised by him either directly or through officers subordinate to him in accordance with the Constitution. Likewise, under Article 154 of the Constitution, the executive power of the state shall be vested with the governor, who shall exercise such power either directly or through officers subordinate to him in accordance with the Constitution. Now, Article 73 of the Constitution provides that, subject to the provisions of the Constitution, executive power of the Union shall extend to matters with respect to which Parliament has power to make laws and to exercise of such rights, authority, and jurisdiction as exercisable by the Government of India by virtue of any treaty or any term. Thus, you see the vast extent of the powers, executive powers. Now, Article 74 of the Constitution says that there shall be Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercises of his function, act in accordance with such advice. Now, Article 163 of the Constitution provides that there shall be Council of Ministers with the Chief Minister at the state level, who shall aid and advise the governor in exercise of the function. Now we come to the Article 309. This is basically deals with the government servant. 309 of the Constitution provides for recruitment and conditions of service of persons serving in the union or the state. Article 310 of the Constitution provides for tenure of office of all members of civil services shall be at the pleasure of the president in case of union, and in case of the state at the pleasure of the governor. So thus we see that the services of the public servant is at the pleasure of the governor at the state level and at the pleasure of the president at the central level. Now, the above are the constitutional provisions which generally deal with the power of the executive. The principles governing the roles and the responsibility of political executive and civil servants are therefore constitutionally defined and also based on the basis of various rules framed by the president and governor for conduct of the business in the government. Ministers are responsible to the people. This is very important in a democracy because they are elected representatives of the parliament as well as the general assembly, state assembly. Civil servants have to be accountable and of course to their political executive. The civil servants are accountable to the political executive, but they have to be function under the constitution. Consequently, they are also accountable to the people in this country. This is what is held in the TSR Subramaniam versus Union of India, reported in 2014 Supreme Court 263. Now, as far as the state of Maharashtra is concerned, there is Maharashtra Civil Services Conduct Rules 1979, which specifies what are the duties of the civil service. And there is Maharashtra Civil Services Discipline and Appeal Rules 1979, which deals with the minor punishment and the major punishments which are to be awarded after inquiry is conducted in case of the breach of the duties by the government. Now, overall, now we see, before that, I would like to quote one paragraph from the Supreme Court in case of state of UP versus Raj Narayan. This is a very old case, which is reported in 1975, Supreme Court 685, where the court very tersely said that in a government of responsibility like ours, where all the agents of the public must be responsible for their conduct, there can be but few secrets. So therefore, the constitutional this constitutional bench, this decision in the Rajnarayan state has been approved and reiterated by 7-judge Supreme Court judge bench in S.P. Gupta's case versus Union of India, AIR 1982, Supreme Court 149.
Dhumaskar sir, तुमचा ऑडिओ जरा वीक आहे थोडासा.
अच्छा. Can you hear now?
या आणि स्लाइड्स कधी मूव्ह करायचे या स्लाइड्स मूव्ह करायचे असतील तर.
Can you hear now?
Advocate Dhumaskar ji, Wi-Fi connectivity on your end is poor, and second thing is you want Neeraj to put on the this thing PowerPoint simultaneously while you are speaking. Do you want it?
Just a minute. Yeah, so it can be another way. Yeah. Now you can
Dhumaskar ji, do you want the PowerPoint?
You can start the slide now. Yes.
Right. Neeraj, kindly put on this thing. Screen sharing.
Yeah. Next slide.
Dhumaskar ji, please guide us how far to go.
Yeah. Next slide. Neeraj. Yeah. Who is a public servant is defined under Section 21 of the Indian Penal Code. The CRPC does not define it, but under Section 2Y of the CRPC, words and expression used in CRPC and not defined therein, but defined in IPC, have the meanings respectively assigned to them in that code. So therefore, the definition of public servant, we have to go look the section 21 of the Indian Penal Code. Next slide. Now, in case of the public servants, these are the categories of the misfeasance, malfeasance, non-feasance, etc. by the public servant. Now, what do you mean by misfeasance? It means an act of engaging in an action or duty, but failing to perform the duty correctly. It is legal act, but improperly performed. Malfeasance means any act that is illegal or wrongful. It refers to an action that is willful and intentional act of doing harm. Non-feasance, by contrast, is a failure to act that results in harm. Now, how to prove misfeasance? So before that, I will give you some example of what is misfeasance. Misfeasance, failing to perform the duty correctly. It is an act of engaging in an action or duty, but failing to perform the duty correctly. In short, it is a legal act, but improperly performed. For example, a police officer sees a person traveling or during the pandemic year, he sees that the person is not wearing mask, etc. And he stops that vehicle of the commuter and start assaulting him with the stick. Now, this is wrongful. Using a force improperly, using his power to misuse in such manner will come under the misfeasance. Now, as regards that is, though he is a government servant, discharging his duty to prevent that person from violating the 188 of the, he is trying to act by exceeding his force by assaulting him. Another example will be there in the police station. A person is called and a police officer slaps him. Now, this slapping is an excess of his power. Therefore, it will fall under the misfeasance. Now, we come to the how to prove misfeasance. It can be proved by leading evidence to show that the accused is a public servant. Now, there has to be first indication that the accused should be a public servant. That such public servant caused material damage. Now, how to prove malfeasance? It can be proved by leading evidence to show that public servant owed a duty of care. Such duty of care was breached by public servant in some way. That the breach of the public servant caused injury to the public, to the plaintiff on account of absence of due care by the public servant. Malfeasance is in a higher level than the non-feasance. Next slide. Now, basically today's topic is basically the as regards the offences under the IPC under section 166 to 171. These are contained in chapter 9 of the Indian Penal Code. Now 166 relates to public servant knowingly disobeying any direction of the law by intending to cause or knowing it to be likely that he will by such disobedience cause injury to any person. Now, in this case, first ingredient will be a person should be, the accused should be a public servant. He knowingly disobeyed any direction of the law, for example, any decision of the court or an order of the court, and he did it intentionally, because in criminal cases, the intention is very important. Intending to cause or knowing it to be likely that he will by such disobedience cause injury to any person. So there has to be the next ingredient in such intention is likely that it will cause injury to any person. Now, injury is defined under section 44 of IPC as any harm whatever illegally caused to any person in body, mind, reputation, or property. It is not necessarily actual injury, because here this is very important. Injury can be non-economical or not in terms of money. Next slide. There is one decision also I have quoted there. Now, 166A and 166B of IPC, these relates to offense related to women, which was incorporated initially by way of ordinance in 2013, and later Parliament passed criminal law at 2013 subsequent to Nirbhaya gang rape case. In this case, the officer, etc., does not record the FIR, etc. Straight away, without sanction also, you can prosecute it. Now, next section is 167 of which deals with public servant framing an incorrect document. Now, this section is also very important. Most of the time, we see that the public servants prepare incorrect documents, or preparation of translation also is incorrectly done, whether physical document or electronic document. And this is done in such a manner that he knows that or believes it to be incorrect, intending to cause or knowing it to cause, knowing it to be likely that he may thereby cause injury to any person, shall be punishable if execution so and so for 2 years, etc. Now, here also the intention. First is the public servant. Secondly, he framed or prepared incorrect document, whether physical documents or electronic documents, and he did it intentionally, knowing it very well that it is incorrect and it may cause, is likely to cause injury to any person. So here also the intention also is very important. Now, section 168 of the IPC deals with the public servant unlawfully engaging in trade. Now, this is also, we often see that though not on record, the public servants many a times engage indirectly in trade or business. So this section can be used, but this is a non-cognizable offense, unbelievable offense. Next slide, please. 169 deals with public servant being legally bound as public servant not to purchase or bid a certain property unlawfully, buying or bidding or for property either in his name or in the name of any other joint family or shares or etc. So this is basically a public servant is debarred from participating in certain property auction, unlawfully buying or bidding property, etc. Now, section 170 also deals with falsely personating any person holding such office as a public servant, pretending to hold any particular office as a publican. This is also punishable. Falsely personating any other person, that he is such and such officer, this is also punishable under this section. Section 171 of IPC deals with wearing garb or carrying token used by public servants, etc. Resembling it into the with the intention that it may be believed that he is likely to be believed that he belongs to that particular class. So this is also punishable understand. This is also cognizable offense, bailable and non-compoundable. Next slide. So this is another important section contained in chapter 11 of the IPC. Section 217, which deals with public servant knowingly disobeying any direction of the law, intending thereby to save any person from legal punishment or subject him to less punishment or save any property from forfeiture or any charge, shall be punished with imprisonment, either restitution for a term up to 2 years or is fine. This section is an aggravated form of offense than the offense under section 160. Ingredients are more or less the same as contained under section, but this is an aggravated section. This is very popular amongst some of the activists also. Then section 218 of the IPC deals with public servants training incorrect or writing with intent to save person from punishment. For this offense, there is a punishment up to 3 years imprisonment and with fine also, and or with fine. Offense is cognizable. This is also section which can be used to check the illegal acts of the public servant. Next slide. Now, giving of false evidence relating to public servants in judicial proceedings, corruptly making a report contrary to law, etc., is contained under 219. This is also punishable, but a punishment is 7 years. But the offense is non-cognizable, bailable, and non-compoundable. So if a public servant corruptly makes a report, false report, contrary to the law, he can be taken to task for under this section. The section 220 of the IPC deals with commitment for trial of confinement by a person having authority who knows that he is acting contrary to law. Punishment for this offense may be extended to 7 years, or is fine, or is both. Offense under this section is non-cognizable, bailable, and non-compoundable. This is also a very important section. He deals with having persons, for example, the police who know that he is acting contrary to the law. Deals with commitment for trial or confinement the person is punishable under this section. Next slide. Now, before we come to this slide, I would like to highlight the aspect of the intentional acts of the investigating officer which causes suffering to the innocent person. And in case of lapses by the investigation officer, what should be done? What should be done? The Supreme Court way back in 2014, as reported in the state of Gujarat versus Petition by etc. reported in 2014, has said that innocent persons are subjected to suffer ignominy of criminal prosecution and to suffer shame and humiliation. This is just like bounden duty of the court to serve the, it is the bounden duty of the court to serve the cause of justice to the victim. So it is the bounden duty of a court to ensure that the innocent person is not subjected to rigors of criminal prosecution. So what happens in case of the such lapses by the investigation officer? A person suffers. The directions are given in this particular case. Please take it to the next slide. It says very clearly, see, every acquittal should be understood as a failure of justice or delivery system. This is a beautiful statement. We never pay attention to this. We say that it happened. The acquittal happened. Whatever we blame this person, that person. Why it happened, we never try to. The Supreme Court tries to find out why it is happening. Now, in serving the cause of justice, acquittal should be ordinarily lead to the inference that an innocent person was wrongfully prosecuted. So the Supreme Court starts with the acquittal should be ordinarily lead to the inference that an innocent person was wrongfully prosecuted. It is therefore essential that every state should put in place a procedural mechanism which would ensure that the cause of justice is served, which would simultaneously ensure the safeguard of interest of those who are innocent. This is very important. This is an aspect as regards the innocently who are charged and acquittal has taken place. In further on to the above purpose, it is considered to direct the Home Department. So here the directions were given to the Home Department of every state. Every state department, so Home Department was given direction to examine all orders of acquittal and to record reasons for the failure of each prosecution case. This was mandated by this judgment, and further directions are given. It is, I will read this particular paragraph because it is very important. In furtherance of the above purpose, it is considered essential to direct the Home Department of every state to examine all orders of acquittal and to record reasons for failure of each prosecution case. A standing committee of senior officers of police and prosecution department should be vested with aforesaid responsibility. The consideration of at the hands of the above committee should be utilized for crystallizing mistakes committed during the investigation. This is very important. And or prosecution or both. The Home Department of every state government will incorporate in its existing training program. So here they speak of this, speaks about training program for junior investigation prosecution officers. Officials course content drawn from the above consideration. The same should be also constitute the course content of refresher training programs for senior investigating prosecuting officers. The above responsibility of preparing a training program for officials should be vested in some committee of senior officers referred to above. The course content will be reviewed by the committee annually on the basis of fresh input. So we see that the training also is also expected and directed in the bill. Go to the please next slide. Therefore, we have we therefore for direct that just go the earlier step. We further direct that the above training program should be put in place within 6 months. So this should be in place already and it should be functioning now. So now the police officers or the prosecutors cannot give any excuses. No, now the next slide we can see. On the culmination of a criminal case in acquittal, the concerned investigating prosecuting official responsible for such acquittal must necessarily be identified. So identification of those who are responsible for this faulty investigation and faulty prosecution should be identified. The finding is to be recorded in each case, whether the lapse was innocent or blameworthy. This is also required to be done. Each erring officer must suffer the consequences of his lapses. So this Supreme Court says very clearly that each officer must suffer the consequences of his lapses by appropriate departmental action, whether called for, taken into consideration seriousness of the matter, the concerned official may be withdrawn. So he may be withdrawn from investigating responsibility permanently or temporarily. This is very important. So we see that constantly the same person is, in spite of having committed so many lapses, he continues to. So this is a check which is already been directed. Now, permanently or temporarily, depending on purely on his capability, we do also feel that we also feel compelled to require the adoption of some indispensable measures which may reduce the malady of suffered by their parties on both sides of criminal litigation. That means the prosecution as well as the accused. The prosecution is taking so much of pains and so much of money is being expended by the state. So they should not suffer acquittals for such lame errors by the and intentional errors by the investigation officers. These are very things to be taken note of. We also accordingly we direct now here the directions are given again. We direct that the Home Department of every state government to formulate a procedure for taking action against all erring investigation. We need to find out now what is the procedure in place in the state of Maharashtra for taking action against all the erring investigation procedures, and whether such committees are being formed and the guilty and the persons who are responsible for faulty investigation are taken to task. All such erring officers will be identified as responsible for failure to offer between can on account of sheer negligence or because of alcoholism must suffer departmental action. So departmental action is a must here. Now, the above action formulation would include seriousness in performance, investigating, and prosecuting duty. Now, this applies to both the police as well as the prosecutors. No, the prosecution and the police department are separated. Prosecution wing is separated, and the investigation, but they are responsible. Those officers who are responsible for such mess need to be taken task. All and ensure that investigation and prosecution are purposeful and decisive. So the investigation and prosecution are purposeful and this is very important because the very aim of the concept of justice is fairness. There has to be fairness in investigation as well as fairness in the procedural aspect adopted. Now, this also direction was also to be complied within 6 months long back. Now, next slide. Now sometimes the public servants oppressive, capricious, maliciously acting. What does those terms mean? The term oppressive means an act inflicting harsh and authoritarian treatment. Now, this normally when, for example, when a person goes to the police station These people sometimes are not, the person who goes to a lawyer complaints are not treated properly sometimes. And they behave as if they are authoritarian. Now, capricious means again given a sudden, means given to sudden and unaccountable changes or mood, swing of mood or behavior. This is also we see many a times. The malahide means act carried out in bad faith or with intent to deceive. Now, this also many a times we see among various public servants. It's common experience that many government servants are tempted to act capriciously, oppressively, and maliciously with malice, that is with wrongful intent. Some even go to the extent of acting dishonestly and fraudulently to appease their greed. They cause wrongful loss to the department. This is very important. They cause loss to the very department they are employed, where they work, and many a times obtain undue advantages to themselves. This is also very frequently done. Or to act wrongfully to cause gain to others for extraneous consideration. Obviously, the greed also comes here. Some frame false records, incorrect manufactured false documents, incorrect records with intent to cheat the department. This is also very serious. Some commit acts of commissions or omissions with malevolent intention to cause wrongful gain to themselves or others, including relatives, friends, wrongful loss to the department and the public. Now, sometimes, many a times, the public servants enter into criminal conspiracy with others, non-government servants also, commit offences. So they can be also taken into task for doing for such wrongful acts. Next slide. Now, 4-judge bench decision of the Honorable Supreme Court, Dr. Vimla versus Delhi Administration, AIR 1963, Supreme Court 1572. In para 14, this is because I have quoted because this is what does these are the defraud. The words are used commonly basically, and what does it mean? To summarize, the expression defraud involves two elements, namely deceit and injury. Now, there has to be principally the deceit and injury to the person deceived. Injury is something other than economic loss, that is deprivation of property, whether movable or immovable, or of money, and it will include any harm, whatever caused to any person in body, mind, reputation, or such other. In short, it is the non-economic or non-pecuniary loss. As I always said, the injury may not be actually the economic, it can be non-economic, non-pecuniary also. A benefit or advantage to the deceiver is almost there in almost always cause loss to the detriment of the deceiver. So whenever such a deceivement is there, there is always loss to the detriment to the deceiver. Even in those rare cases where there is a benefit or advantage to the deceiver, but no corresponding loss to the deceived, the second condition is satisfied. That is, even if there is no actual loss to the sufferer, it can be taken to task. Because there is an advantage taken already while deceiving. This is a very important decision. Another next slide. Now, this is generally I am saying about the corruption cases. How the corruption is eating our fabric of our democracy. This is very beautifully stated in this case. In Sumanlata Bhagat versus State of Others, reported in AIR 2016, Jammu and Kashmir, page 52. This is a division time. I would like to read this. Please understand this. Really how firstly and beautifully you say. The greatest challenge to the body politic is from Hydra-headed monster of corruption. This is a Hydra-headed monster that is the nature of the corruption is such an extent. Okay. Yeah, the Hydra-headed, multifaceted monster corruption. The menace of corruption has corroded the fabric of human values. The menace of corruption has corroded the basic human values. It has created neo-rich class in the society. See, corrupt people are parasites who swell themselves by sucking blood of poorest of the poor. Basically, most of many times it is the poorest who suffer. The society gets destabilized by the abominable corrupt practices indulged into by black sheep in the society. Such corrupt people are black sheep in the society. Major portion of the public funds are siphoned off into the pockets of few corrupt people, and this in turn has potential of breaking down the economic backbone of the nation. This is very hurting. This is see how the major portion of the public funds are siphoned out into the coffers of few corrupt people. So this has to be checked. Corruption is the greatest threat to the democratic institution. This is very true. Democracy is threatened every now and then. Corruption is everywhere. I am not saying that it is not there in the other Western countries, but to the extent it is in our country, it is very disturbing. No, corrupt practices of small band of people inflict untold and unbearable miseries on the poor and downtrodden class of the society. Corruption, if unchecked, will eventually lead to anarchy in the society. Next slide. To ward off all evil effects of corruption, lawful rule is imperative. Rule of law is a must. It is seen and it is of common knowledge that corrupt people from power centers and with passage of time take control of them. This is we are experiencing this everywhere in our country, particularly in our present state, our state also. Corrupt people from power centers and with passage of time take control of them. So who is controlling? So this has tendency to control the power. Now, of all impending challenges faced by the society, corruption is a serious one. This is very true. Corruption is my mother of all evils. It is the mother of all evils. Still, we are not acting sufficiently to check it. Earning tons of money, amassing huge wealth at the cost of the poor is a beastly instinct. See how beautifully the judge explained. The malice of corruption has afflicted every organ of the society. That's very true. No organ of the society is spared by this corruption. The experience has shown that corrupt people survive because of active support they get from the people who are put in important positions of trust. This is very true. The experience, our experience, day-to-day common people's experience shows that the corrupt people survive. Why they survive? Because of the active support they get from the people who are put in important position of trust. And we do not react, nor do we act sufficiently to check that. Therefore, it happens. Our Senoi ji has a beautiful line to say in this thing. World suffer because of the silence of the good people, not because of the bad people. That's very true. I agree with that. Therefore, we must do something. The corruption now continues. The corruption has potential of destroying all the democratic institutions. It has tendency to destroy all the democratic institutions. It will not spare anyone. The monster of corruption, if not taken head on, will in the near future convert the society governed by rule of law into society governed by the rule of jungle. That is almost taking place to some extent. This we need to check. Those who are holding the position of trust for public good, if would continue to facilitate the corrupt activities in the near future, will themselves get consumed as the monster of corruption will not spare anyone. So it is required to check this. Next slide. Now we see in A.R. Ankule's case, RS versus RS Nayak, 1988 Supreme Court 1531. This is what the Constitutional Bench stated. Through Justice Sabasati Mukherjee, we must remind ourselves that the purity of public life is one of the cardinal principles which must be upheld as a matter of public policy. So the Supreme Court says very tersely, we must remind ourselves that the purity of the public life is one of the cardinal principles which is a matter of public policy. It is our public policy that we need to have purity of public life. Therefore, allegations of illegal infraction and criminal infraction must be investigated in accordance with law and procedure established under the Constitution. So therefore, the Supreme Court says the allegation of legal infraction, violation, criminal infraction, criminal violation must be investigated in accordance with law and procedure established under the Constitution. Even if he has been wronged, like the Supreme Court says it, even a person has been wronged, if he is allowed to be left in doubt, that would be cause more serious damage to the offense. That is the person who is accused of corruption. If he is left in doubt, he will be left in doubt. That would be still worse. It says. Public confidence is very important. Public confidence in public administration should not be eroded any further. One wrong cannot be remedied by another. This is very important. Public confidence is at stake. We as a public have legitimate expectation that public administration will function with purity in public life. Next slide. Now we come to the sanction aspect. The one section if you want to prosecute any person, section 197 says that you need to take a prior sanction. Now, prior sanction from the appointing the person appointing a party or the person who can be removed, that government servant who can be removed by the authority sanction. Now, there is a practical difficulty, and I will read the section 197. This is very important because here protection of judges and public servants. This is the heading. When any person who is or was a judge or a magistrate or a public servant not removed from his office save by or with the sanction of the government, he is accused of any offense unless to have been committed by him while acting or purporting to act in discharge of his official duty, no court shall take cognizance of the matter. Now, this decision is very important. This is a constitutional bench decision of the Supreme Court, which is still holds the free. This says that the result of origin dispatch and result, there must be a reasonable connection between the act and the discharge of official duty. The act must bear such relation to the duty that the accused could lay a reasonable but not a pretended or the fanciful claim that he did it in the course of performance of his duty. In short, what is this? This regime says that the public servant's act while discharging his official duty must relate within the ambit of the scope of his official duty. Now, while sometimes it happens, sometimes what happens, the public servant, for example, the police officer, while arresting a person, sometimes they use force also. So while arresting a person, while in discharge while discharging his duty to arrest a particular person, if he uses some force, which was required to arrest them, then in such a case, sanction will be required, because though he exceeds his official duty, he is covered under the liberal interpretation of the term. He is wearing the cloak of that office. Therefore, he is protected. Therefore, tire sanction. This protection basically, next slide. This protection is basically given to the public servants, so that there is people do not unnecessarily prosecute the public servant and harass them. So this protection also is important, also is essential. So there has to be actually the balance. Not all the acts of the public servants are protected. The section 197 is constituted strictly, but once it is shown that the official, while performing his duty, exceed his act, thereby he commits certain acts, he gets the protection. He gets the protection basically. While he is using, I have given example, while arresting a person, he is using a little force to arrest the person. Then he will be protected, because he will be protected under 197. So sanction will be required. Now, it is important to note that what are the tests already I have said. Basically, that is the Mata Jokes case. That is the test which is applied everywhere. Now, it says now, on a consideration of this case says now, this is AR 72 criminal law journal, which is single judge of the Calcutta High Court case also. This lucidly explains the history of enactment of 197. On a consideration of the aforesaid cases, I ultimately hold that the tests for sanction of 197 CRPC that has received the imprimatur, that is the approval of the judicial, are that there must be a reasonable connection between the act and the discharge of official duty. So this is what the Supreme Court has said, that the two must be so interpreted that it can reasonably postulated with the act so done by the accused in the performance of official duty, and that even if such act appears to be in excess, this is what I said, this in excess of what is strictly necessary for the discharge of such duty, the consideration of that question is to be deferred till a later stage when the trial proceeds on merit. Anything beyond that would be the horse of the intention. So the sanction, the objection as regards the sanction not being obtained can be taken any stage of the proceeding also. Whether now sanction is required in a particular case is ultimately a question of fact. Now further it is elaborated also. Next slide. The history is given why section 197 is so subject to sanction under section 197, the public servant can always be prosecuted for offences. Now there is a Maharashtra Act of 33 of 2016. It says that prior sanction to investigate offences committed by public servants as provided under 197 of CRP is required before magistrate take cognizance. This is basically, I am not very happy with this provision. Why this is required? Why this was required? Now, investigation of offences committed by public servants as provided 197 is required before magistrate take cognizance of offences. If sanction is not granted within 90 days from the date of receipt of application, it is deemed to be granted. Now we have to apply for sanction. Otherwise, the case will be thrown out. If you don't get the sanction, you can't prosecute the public servant because he gets the protection of 197. So if within 90 days the sanction is not granted, it is deemed to be granted. Then you can prosecute. The sanction issue can arise at any stage, even after conviction also it can be taken up also. Next slide. Next slide, please. Now these are the definitions, dictionary meaning of the consent, sanction, etc. has been stated. You may go through that. Next slide. What does the word sanction mean, etc. Now here, this is another aspect which is very important. This is very, very important. This, please note down this decision also. State of Bihar and another 6 and so versus 3PP Sharma and another reported 1991 Supreme Court 1260. It says that sanction under 197 CRP is not an empty formality. It is essential that the provisions therein are to be observed with complete strictness. The object of obtaining sanction is that the authority concerned should be able to consider for itself the material before the investigating officer, before it comes to the conclusion that the prosecution in the circumstance be sanctioned or forbidden. To comply with the section 197, it must be proved that the sanction was given in respect of facts constituting the offence charge. It is desirable that the facts should be referred to on the face of the sanction. So section 197 does not require the sanction to be in a particular format. So what is required that the reasons must be disclosed about the offence committed. If the facts constituting offence are not shown on the face of the sanction, it is open to the prosecution if challenging to the proof beyond the court that the such facts were placed before sanction authority. It is open to the prosecution if challenge to prove before the court that those facts were placed before the sanction authority. It should be clear from the form of the sanction that the sanction authority considered the relevant matter. This is very important. Sanctioning authority should consider the material before it, placed before it, and after consideration of all the circumstances of the case, it should sanction the prosecution. Next slide. Now this is a case where prosecution of private banks officers also concerned. This is two-judge bench decision. It traces out the object of the legislating the Prevention of Corruption Act. It deals with the history of why it was, because the offences which are there in the Prevention Corruption Act, earlier 161 to 165, etc., were deleted from the IPC, and the more stringent punishments were provided under the Prevention of Corruption Act. So in this case, when the private bank officials, the directors, managing directors, can be also prosecuted. This is what is kind of. Yeah. Next slide. The history of the Prevention of Corruption Act here I have just cited because this is not the subject of our today's session, but I have given you the basically the definition contain of prosecution of private banks. So this is the same thing here. So 161 are incorporated in the legislation. This is what I have said. 161 to 165A of the legislation are enhanced. So and incorporated in the Corruption Act. In the provision of the 161 are incorporated in the provisions against with the enhanced punishment. It is not necessary to retain this again. So it was felt that it was not required to retain in the IPC. So it traces our next slide also. It next slide please. Now this also further discusses about the objects of that bill introducing the Prevention of Corruption Act. Next slide. Yeah, what is important to the purpose of this section is that chairman here, the chairman and director are said to be public servants for the purpose of Chapter 9 of the Indian Penal Code. Every chairman who is appointed as a whole time managing director, auditor, liquidator, manager, any other employee of a banking company shall be deemed to be public servant for the purpose of Chapter 9 of the Indian Penal Code. So this is what it is being said. This is generally as regards the prosecution under the Corruption Act, Prevention of Corruption. Next slide. The same, it is giving the here the court also distinguishes the decision, earlier decision, which earlier said that you can say, this case it is held that a private company carrying banking business as a scheduled bank cannot be termed as a company carrying out in case. In the third case, the court was examining as to whether it can be issued under 226. There was no issue before the court. This is the how this section 46A is applicable and maintainable also further issues. Next slide. This is Narasimha Rao's case. What is the word office normally understood? It is described. It is discussed there. The case law also is discussed of. Next slide. This is as regards the same further how the banking section 46A is addressed. It is also stated also. Next slide. This is also Manish Trivedi's case also. This also discusses the various aspects of the corruption and the public servants deemed to be, because there is deeming provision also is there. Speaks about the deeming provision. Next slide. Yeah, continuation of the same also. Though it says that though it is not defined under the public servant does not fall into, but there is a deeming provision in a separate statute, then also it will fall under the public servant, definition of public servant. Yes, next one. Yeah, this is with reference to the continuation also. Next slide. Yeah. Here it says now, in this paragraph, the Supreme Court says, in the light of the law laid down by this court, as above, it is clear that the object of enactment of the Prevention of Corruption Act was to make anti-corruption law more effective and widen its coverage. Has it happened? I am asking all of you. In view of definition of public servant in section 46 of the Constitution, as amended by the Director operating under for already public servant assets, they cannot be excluded from the definition of the public servant. In view that what is the general definition of public servant given it is in the definition of public servant given as So this is as regards the with again the section 46A of the Banking Regulation Act also. Next one. Yeah, this is continuation of the same. In short, now, yeah, next slide. This is continuation of this. Yeah, next one. Yeah. Now, in briefly, I will say that the prosecuting a public servant is basically the state duty. A separate department is formed to prosecute, and the state is spending money to discharging its duty, and that money has to be properly utilized. Now, many a time the public servants, and obviously because to save their skin, they are taking the shelter of the prior sanction under section 197. So therefore, it is advisable that whenever the government servant is concerned, if his acts of the such government servant is little bit exceeding his official duty, then he will take the shelter of the bar of 197 and prior sanction. And if you don't take the prior sanction, the court will not take you from that and the case will fail. So therefore, this is very important while considering the aspect of prosecuting the public servant. Now, we have to maintain a balance here, merely because we have the various sections. We must not misuse it. We must not misuse it. We must use it in a balanced way and use it wherever it is required. Otherwise, the court is going to take a serious view of the matter and they may not accept the prosecution case and they may throw it out. So it will, in the waste of expenditure, expenses, waste of energy, waste of time. So therefore, the time has to be time and money of the state government also, and our public money has to be saved in maximum, in a way, it will give a maximum benefit in prosecuting a public servant wherever it is required. Now, if you have any answers, questions.
Yes, Dhumaskarji, thank you so much. I request everyone to kindly keep pen and paper ready. I hope you all have noted down the queries that you have as we went along in the PowerPoint and Advocate Dhumaskarji's talk. Those who wish to ask queries, kindly raise your hand or send a message on the chat box so that our admin, Mr. Neeraj Patat, will take up one by one. And those who wish to access the PowerPoint displayed by Advocate Dhumaskar ji can go on to that link which has been given in the chat box and see this on the screen. It is uploaded on our microblog on this link and the path given over there. It's given in the chat box by our admin just now. So you may kindly note down that this thing, it will be uploaded on this website also, petitiongroup.com. So y'all can. Hello. Y'all have queries? You may put it. Kindly put your. Kindly raise your hand one by one, please. Neeraj, are the queries coming in the chat box?
No, sir, I don't see any.
Acha, okay. Request everyone to raise your hand, whoever wishes to ask queries over here on the matter spoken by Advocate Dhumaskar ji. Natrajan ji, Kamlakar, Suresh Acharya, you all have any queries? Neeraj, kindly take up the query put forward by Clarence.
Clarence, sir, I have unmuted you. Kindly speak up.
Hello. Namaskar, sir.
Yes.
Hello.
Yeah.
Yeah, I can hear. No, regarding this is BMC, actually, in spite of repeated complaints when no action is being taken. So, and we intend to prosecute them now for BMC officials. How do we proceed in that?
Yeah. Section 86A of the Municipal Corporation Act 1888. Commissioner is the competent authority to sanction prosecution of municipal officers and servants.
Okay.
And the commissioner has to inform the municipal council, corporation, in the next meeting of it. So the sanction has to be sought from the municipal commissioner. And if it is a commissioner himself, then you'll have to take a sanction from to prosecute from the chief secretary from the state government or the government, state government. Yeah.
No, but problem is if like it's a low level officer, so is sanction required actually, whether that is part of his duty, if he's enacting, whether inaction can be taken as corruption. So and then sanction is required or not required?
Action, see, basically therefore what is the specifically the act, what is the specific act of the public servant that needs to be. He becomes a public servant. He is being an employee of the BMC. He is a public servant. So any act, he may take the stand that I did it while in discharge of my duty. Now, according to his act is beyond the scope of the or it has no reasonable connection with his official duty, then there is no sanction required. To be on the safer side, what is the nature of the offense here? That is required to be seen. Because because they take the advantage of this. Because they take the shelter of the sanction not being granted, and therefore the entire prosecution fails. So the precaution has to be taken. Now you say that if now for example, if BMC officer is demanding bribe, it is not part of his duty, no sanction is required.
No, like in certain cases when notices are served under MMC Act or MRTP Act, but further to that, no action has been taken. Shall be taken. This is actually an act of corruption or deduction.
No, you will need the commissioner's sanction. because he will take, his act is, he is not acting person. He has taken initially, and thereafter he is not taking any action further.
Right. Right.
Correct? So that is why he is not acting while he is expected to act. So therefore he will take the, because if the sanction is necessary here, because he will take that shelter, and otherwise the case will suffer. Your entire case will be thrown out.
Okay. And if you want to seek any legal remedies for this case, because sanction will definitely not come.
Kindly see the Mata Jog judgment also. If you want a full judgment, I can forward it also. If your act, if the act of agency has a reasonable connection with your official duty, then you need a sanction. This is the test broadly. So normally they take this. I have issued initially action. Thereafter, I whatever is bona fide mistake. Hello, can you hear me?
Yeah, I can hear.
Yeah. What is that you are saying?
Sanction is required, you mean to say, most of the cases.
It is better to take a sanction.
Okay. No, because definitely sanction is not going to come at any cost from the municipal commissioner.
No, not going to, you have to apply, apply and see, no.
Achha, okay.
And otherwise also if within 90 days sanction does not come, it is deemed to be granted, no.
Okay.
And they have to give a reason, because even if they refuse the sanction also, they have to give a reason. Every administrative order requires to give a reason. Without giving any reasons, that order will not be good order, that will be set aside.
Okay. Thank you.
Dhumaskar sir, I have a question.
Yeah.
So as you said, under 166A IPC, sanction is not required, prior sanction. Let's say if I'm invoking 167 and 218 for framing incorrect document along with 166A, then will prior sanction be required as per CRPC 197?
No, because one of the sanction, the required sanction, so as far as that offense is concerned, the court will not take offense.
Okay, so you mean to say the this thing sanction would be required if I'm invoking anything other than 166A. Okay, and let's say if I'm invoking only 166A, then since it's a cognizable offense, shall the normal route be followed for 154.1, 154.3, and then 156.3?
No, 1 second. No, if it is a organized offense, then a FIR has to be recorded. He has no the 166. 1 second.
Okay.
You said 166A, no?
Yes, sir.
Whoever being a public servant, knowing these are the. No, you are reading 166A. No, IPC, no? You are referring to 166A, no?
Yes, sir. 166A IPC.
IPC. So this section can say the
Public servant disobeying direction under law.
Direction can say. Yes. (166A) you don't require a sanction.
No, sir. Sanction is not required. That's fine. But if we need to prosecute, then do we need to follow the same procedure for cognizable offenses, the 154 route?
Procedure, sanction is not required. No, he has to accept the FIR has to be registered. If he does not, then
correct. So we should go for 154 1 CRPC under SHO, and then 154(3) to the DCP and then 156(3) to the court.
Cognizable offense, these are cognizable offenses, no? Only.
Yes, sir, it is cognizable offense. Okay, so I'll take the next question. If police is closing cheating complaint, stating that it's a civil matter, then how can we prosecute the concerned officer?
No, cheating case, the closing the case, the police cannot close it. One second. It has to be referred to the magistrate. If the magistrate, if the matter is referred to the magistrate for closing the case, the magistrate will issue a notice to the complainant. And there you can raise your protest petition. In protest petition, you can give your objection, whatever ground is. Yeah, I has not taken this, that, etc. Civil offense is a civil nature. It's a different aspect. Now the criminal, when offense is clearly made out as regards the IPC offense as concerned, merely saying that it is a civil nature or nothing, that will not be used.
Sir.
That will not hold water. The prosecution, you can always submit your protest petition, giving your objection.
Sir, the protest petition has to be submitted to a senior officer or directly to the concerned court?
The court will issue a notice, no?
The jurisdictional court?
Yes, correct.
Okay. And sir, the next question is, in certain cases, we have observed that before registering the FIR, the police officer usually writes to the police prosecutor asking for the opinion whether the FIR has to be registered or not.
Yes, sir, wrong practice, they cannot do it.
Okay, so it's not valid, right?
Kindly go through the Lalita Kumari's judgment. That's a exhaustive judgment, constitutional bench decision. Para 111, Chano is well versed with it, and others are also well versed. This is a decision where it says that the inquiry, whatever they can say, they have to do it in those specified cases only.
So true, Lalita Kumari judgment is there.
Whenever the cognizable offense is made out, it is mandatory to register the FIR.
Correct. That's true. But are there any judgments in which
it is not required at all?
Are there any judgments in which it is specifically mentioned that
Why you require a judgment? The law does not say, the procedural law does not say so.
Okay, sir, got it.
Yeah, this is the code which is generally applicable. It does not say so. So why you require the case law also?
Okay, so which means the practice which they follow is completely illegal and not as per the law.
The entry of the prosecutor will come there. They are appointed under section 24, 25 of CRPC. Correct. So their scope will come later on, because they are later on, not at the before registering whether it to be registered or not. We have no business. It is the investigating officer, station house officer. He has to apply his mind and register it.
Sir, in case if they tell the applicant that we are seeking opinion from the police prosecutor or public prosecutor, then what can the applicant do? I mean, what are the recourse for the applicant, for the activist or applicant or whoever is making this cognizable offense complaint?
No, sorry.
Sir, if the SHO or the police officer say that we are seeking permission or we are seeking opinion from the police prosecutor, then what are the recourse which is available to an applicant?
Now we ask him in writing.
Okay.
Ask him to give in writing that you are seeking, then you have a right to go and to the High Court and say that he is asking this. This is contrary to the mandate of law is violated, because Lalita Kumari case and the section 154 also very clear. You have to, when cognizable offense is made out, you have to register the FIR. You have no other excuses to give. And that will amount to contempt of court. You ask the High Court to initiate contempt.
Thank you, sir. Gaurang bhai, please take over.
Yeah, any other question?
Hello, Neeraj. Mr. Chairman has put a query over there in the chat box. Kindly take it, please.
Sir, I have unmuted him. Cherian sir, please go ahead.
Mr. Chairman, kindly speak, please.
Am I audible? You
Yeah,
can hear
speak.
me now?
Yeah, we can hear you.
Deputy Registrar Cooperative Societies issued a notice under Section 154B27 of MCS Act to issue the information required by a member.
Yeah, voice is not audible yet slightly. Yeah.
Deputy Registrar Cooperative Societies, K. Stewart, issued a notice to the society instructing them to give me the required document under Section 154B27. Till date, they have not given it, and there is a provision in the MCS Act, and if they fail to do so, 100 rupees per day is to be levied from the concerned. And for that, I made a complaint to the Deputy Registrar, but he is not taking action.
No, sorry, the Neeraj, voice is not audible.
Sir, whose
In that
voice?
case, my
Mr. Chairman, please use the earphone and a microphone, microphone, so that your voice is clear. Here, there's so much echo that you are unable to say it clearly.
my question is clearly put on the chat box. If you could, if he could read that.
Hello.
Neeraj, is it possible to put the query on the screen? Mr. Chairman's query on the screen? One minute. Dhumaskar ji, please wait.
Yes.
Dhumaskar ji, please read the query on the screen, please.
Not provided. Now the 154 order is passed to
154 order is issued by the Deputy Registrar to the society.
Hello.
So he's saying the
Hello?
order has been issued to the society by the Deputy Registrar.
Any order which is passed and which is not complied with, the authority can be approached and ask him to take action as against that. Alternatively, there is a provision also in the Cooperative Societies Act. I have not got the Cooperative Act also. Where
I approached Deputy Registrar, who is the authority.
Pardon? Sorry.
Deputy Registrar Cooperative Society is the authority, and I approached him in writing, but he is not responding.
If he is not, then if he is not responding, then he is not responding at all.
In that case, I can initiate the prosecution through the Registrar of Cooperative Societies, Pune.
If you want to prosecute now, then say basically under the this also, you need a sanction from the registrar also, prior sanction, because what is only on the registrar giving a sanction, the prosecution can be done. And if as far as the offences are which are there under the Cooperative Society Act.
Okay, thank you.
If the appeal, revision, etc., whatever remedy is provided under that, you can proceed under that also. And but if you want to prosecute, then you need a approval from the registrar.
No, prosecution is not my aim. My aim is to get the information.
Sorry, my voice is not very clear.
What I need is the information not prosecution. Prosecution is a remedy, as a remedial action I was suggesting. If I get the information directly from the society, that's fine. How to get that one? If that's not happening, shall I go for prosecution?
So he says he needs the information, and if information is not provided by the concerned authority, then shall he proceed ahead for prosecution?
Exactly.
Yeah, prosecution we can get, but again the sanction aspect also will come. Prosecution under the IPC you can do it, but the sanction aspect will come because we will get the.
So Charian sir, what Dilip sir is saying that prosecution can be done, but then again the sanction aspect would be applicable as per CRPC 197.
Okay, thank you.
Voice was not very clear. Any other question? Because the cooperative society, there are provisions also. There are, because I have not, this is not the subject of it, therefore I have not. But I can guide you if you want. You can send me a email. Clarence is having my email. I will.
Okay, I will send the email to you separately.
Give you detail. Yeah.
Okay. Thank you.
If you want to prosecute, the sanction aspect will also come.
No, my purpose is not prosecution. My purpose is to get the information.
If they don't give the information, then what?
Charian sir, we are going on a loop, I believe. So, yeah.
Okay. I will send a separate email to you.
Karang bhai, are you there?
Yes, I'm here.
We don't have any more queries coming in from the participants.
Okay.
The mobile number for Advocate Dilip Dhumaskar sir is being displayed on screen. So I request all the participants to kindly note it down in case if you wish to connect with him. But please message him prior to giving him a call, because he is also a very busy person. So kindly message him, SMS him, or kindly WhatsApp him prior to giving me a call.
Right. Everyone, please note down, as Mr. Neeraj has said, note down the WhatsApp number of Advocate Dilip Dhumaskar ji from the screen. Preferably, do not, unless it's an emergency, kindly WhatsApp him prior to calling, so that once he gives you permission to call, you can speak to him and get your grievance redressed. So, if there are no more queries, we can wind up over here.
This is thank you. Only one thing I would say before we wind up. This was my first webinar, so I am not used to this. So please excuse me if I have not done it as expected. But if you have any queries, you are free to feel free to email me, whatever. I will answer all your queries to satisfy any queries as regards the criminal aspect, civil aspect. So you can also file civil suits also, take action for tort also. There are various aspects also, because it's such a short period, short time span, you cannot explain everything. So that is a limitation also. But if you have any queries, I will be happy to answer anything. But only don't ask me anything as regards pending matters and which are sub judice matters, basically. Other opinion, what you can say, I can generally, I can definitely give you.
Is because the email ID is not mentioned anywhere in the PowerPoint presentation.
Advocate ADG dot Dhumaskar, DHUMASKAR, Dilip, DILIP, 2 @gmail.com. I will WhatsApp you also. There is so much of material, there are so much of case laws, and even the courts are getting confused, even after so many Supreme Court judgments. Yeah, Dhumaskar is. So sanction aspect, we can say to be abundant caution, take sanction. My advice would be abundant caution, take sanction and proceed. But in the cases wherein the other IPC offenses are involved, for example, extortion, etc., etc., those fall beyond far beyond the official scope of the duty. So there the sanction aspect is not required. It depends on the facts and circumstances of each case. The Supreme courts have been deliberating so many years. But the guiding factor, the decision will be of that Mata Jog Constitutional Bank decision. That will help you. Yes. Sorry for interrupting. Oraji.
Yes, Kamlakar ji is raising his hand. Neeraj, kindly unmute Kamlakar ji.
बाद में देखिएगा क्या है।
हेलो।
कुछ बंद मत करो, बाद में गड़बड़ होगी।
हेलो।
सब करने तो आपका इज्जत जाएगा बाद में।
हेलो।
देख लो उससे बात।
कमलाकर बोलो।
हाँ हेलो,
क्या है?
आवाज आ रहा है?
हाँ
अच्छा, देखो
पंखा नहीं है।
अभी किसी ने पूछा था कि वेदर प्रोसिक्यूटर का ओपिनियन के बारे में पूछा था। हेलो। हाँ, तो ओपिनियन लेना बिल्कुल गलत है और वो पुलिस ऑफिसर को आप 166A में लटका सकते हो, क्योंकि ऑफिसर को ये खाली देखना है कि वो जो कंप्लेंट आया है उसमें ऑफेंस डिस्क्लोज होता है कि नहीं, खाली इतना देखना है तो उसको पीपी की जरूरत नहीं होती है। एंड ही कैन नॉट टेक एनी असिस्टेंस ऑफ द विटनेस और द एक्यूज्ड और एनीवन एल्स। सो इमीडिएटली वो नोटिंग लीजिए आप और पुलिस ऑफिसर के खिलाफ प्रोसिक्यूशन को जाइए। दूसरा बात यह है कि चार्जशीट जब फाइल करते हैं तो अभी एक नया मॉनिटरिंग कमिटी करके इस्टेब्लिश की है इन 2015। तो वो पुलिस ऑफिसर को डीसीपी और पीपी और एक असिस्टेंट कमिश्नर इनके पास जाके वो कैसे चार्जशीट फाइल कर रहे हैं, मॉनिटरिंग कमिटी विल लुक इनटू द मैटर और उसमें डेफिशिएंसीज होगा तो उसको बताएंगे आप ये नहीं करो, ये नहीं करो, वो नहीं करो। तो डायरेक्ट कोई भी ऑफिसर विदाउट परमिशन ऑफ मॉनिटरिंग कमिटी कैन नॉट फाइल अ चार्जशीट। अभी मैं अपना एक्सपीरियंस बता रहा हूँ कि मैंने 42 नंबर कोर्ट में मेरा आयोग ने झूठा सबमिशंस किया था और सी क्लासिफिकेशन रिपोर्ट फाइल किया था। सो मैं कोर्ट से ये आर्ग्यू किया कि he has played a fraud on the court and he has misrepresented the true facts of the court before the court, and therefore he should be prosecuted under 193, 199 for making a false submission on oath। तो उसको हम एक्सपर्ट करेंगे और धुमस्कर जी इसमें हमको जरा गाइड कीजिए कि हमको कैसे जाना है। दूसरी बात यह है कि we can also ask the court to direct the Director General of Police (DGP) to initiate disciplinary action against the officer for making false submissions before the court। So ये सब चीज का धुमस्कर साहब अगर हमको गाइड करेंगे तो बहुत अच्छा हो जाएगा।
I'll be happy to guide you. I'll be happy to guide you. If you are in the right track, you are on the right track.
Yeah, no, what I mean to say is that लोगों को भी आप उसमें थोड़ा सा गाइड करेंगे तो अच्छा रहेगा।
Definitely. As a test case, we can take the matter to the conclusion. Definitely.
Yeah. So just I wanted to inform all participants that सी क्लासिफिकेशन रिपोर्ट फाइल करने के बाद आप खाली लड़ने का और सी क्लासिफिकेशन कैंसिल करने के लिए नहीं लड़ने का। सी क्लासिफिकेशन कैंसिल भी होना चाहिए और पुलिस ऑफिसर को तकलीफ भी होना चाहिए, उसको प्रोसिक्यूट भी होना चाहिए। जब तक हम पुलिस ऑफिसरों को प्रोसिक्यूट नहीं करेंगे, जब तक हम जो पब्लिक सर्वेंट जो गलत काम करते हैं उनको प्रोसिक्यूट नहीं करेंगे, तब तक ये हमको सताते रहेंगे। तो जैसा हमको डर रहता है कानून का, वैसे उनको भी कानून का डर आने के लिए हमको उनको प्रोसिक्यूशन करना बहुत जरूरी है। Is that okay?
Perfect.
कमलाकर सर,
Yes.
जैसे कि आपने कहा ये विधि अधिकारी हो गए, पीपी का ओपिनियन लेना गलत है। तो अगर कोई एप्लीकेंट है जो एग्रीव्ड विक्टिम है, जिन्होंने कंप्लेंट दिया हुआ है एफआईआर रजिस्ट्रेशन के लिए, ये इनका नेक्स्ट स्टेप क्या होना चाहिए? नोटिंग सब कुछ है, वो आरटीआई के थ्रू में प्राप्त कर लेंगे वो।
देखो मैं मेरा एक एक्सपीरियंस आपको बोलता हूँ। इसी तरह से मैंने सबब के पुलिस स्टेशन में कंप्लेंट फाइल किया। आयो वाज वेरी गुड पर्सन, उसने लिखा कि हमको एफआईआर रजिस्टर करने का परमिशन दे दो। तो सीनियर पीआई ने भी लिखा कि एफआईआर रजिस्टर करने का परमिशन दे दो, एसीपी ने लिखा कि एफआईआर रजिस्टर करने का परमिशन दे दो, मगर हमारे डीसीपी जो है वो बदमाश निकले और डीसीपी ने कहा कि ओपिनियन ले लो। तो ओपिनियन लेने के बाद ओपिनियन अपने फेवर में आया। ओपिनियन हमारे फेवर में आने के बाद में आयो ने वापस पूछा कि एफआईआर रजिस्टर करने का परमिशन दे दो। तो तब तक दूसरा डीसीपी आया, उसने वापस ये किया कि स्टेटमेंट रिकॉर्ड करो स्टेटमेंट। तो उस टाइम पे मैंने उनको बोला कि आप गलत काम कर रहे हो एंड आई मूव्ड द कोर्ट बिफोर फॉर प्रोसिक्यूशन ऑफ दो डीसीपी। मैंने आयोग को छोड़ दिया, एसीपी को छोड़ दिया, पीआई को छोड़ दिया और मैं सिर्फ डीसीपी, एडिशनल सीपी और जॉइंट सीपी को मैंने प्रोसिक्यूट करने का मजिस्ट्रेट कोर्ट के पास एप्लीकेशन किया है, बिकॉज they are interfering in the discharge of duty of the police officer and the DCP has got no right to interfere in the investigation and to interfere and give directions whether to register FIR or not. It is only under section 154 subsection 3 when an applicant makes an application before the DCP, only then the role of DCP starts. तब तक डीसीपी को बीच में आने का सवाल ही नहीं आता है। और ये आदत हो चुकी है हमारे डीसीपी, एडिशनल सीपी और जॉइंट सीपी की कि इन लोग पुलिस स्टेशन को सही तरह से काम करने देते नहीं है। और हमारे जो पुलिस ऑफिसर से पुलिस स्टेशन के वो खाली पोस्टमैन हो गए हैं, वो जो सामने ऊपर बोलेंगे रजिस्टर करो तो करेंगे, नहीं करो तो नहीं करेंगे। और इसके लिए हमको वो डीसीपी, एडिशनल सीपी और जॉइंट सीपी को प्रोसिक्यूट करना बहुत जरूरी है ताकि ये सिस्टम बदली हो जाए। इज इट ओके?
करेक्ट करेक्ट कमलाकर जी, यस। Dhumaskar ji, हाँ।
So shall I move out, sir?
Yeah.
Why move out?
सर कमलाकर सर,
हाँ।
होल्ड ऑन। ओके, जैसे कि आपने कहा आपके केस में एसीपी ने परमिशन दे दिया, सीनियर पीआई ने परमिशन दे दिया। इन मोस्ट ऑफ द केसेस वी हैव ऑब्जर्व्ड is that the senior PI usually does not give permission.
Yes, yes, 75 to 80%, yes. You're
Correct. So in case, if the senior PI is not approving, and they are playing, the SHO is playing mischief on their part, then where can the applicant move?
So
Shall he move to the
make,
ACP or DCP or how?
You
Or
should make
directly
an
to the court?
application. You should immediately make an application under 154 subsection 3.
Okay, sir. Wonderful. Yes, sir.
Immediately make an application and tell them our formats are all given where the DCP has got no right to say anything else but to say whether to register an FIR or not, because 154(3) subsection 3 says that the DCP shall act as an investigating officer or shall appoint a subordinate officer who has got the power of the inspector in charge of police station for that particular case. So the DCP has got only two options. One is to direct registration of FIR or to say there is no offense disclosed. But he cannot say necessary action. As soon as he says necessary action, you prosecute him for under 166A. And this is the regular thing. Now, I'm prosecuting one of the all the officers from IO to ACP to DCP for playing mischief with the under section 154A, 154 CRPC. So we are preparing the formats. In fact, today itself, I have sent a notice to DCP. I will share it very shortly how to file the complaint, because I also request all of you to, when you file a complaint, you also refer to a circular called 17/6/2016, which discloses that how the inquiry against the police officer by the senior officers should carry out. And that is a very important circular. Now I'm using it everywhere, which can put all the police officers in a dock. And also rely upon Regulation 10 of the Delay in Discharge of Duty Act, which says that within 7 days the officer shall reply. So you mention these two important laws when you make an application against the police officer or the subordinate officer before the senior officers. As far as BMC is concerned, you mentioned 64C. 64C is a replica of Regulation 10 of discharge of delay in discharge of duty. So you have to use many such things. Then there are other circulars for BMC, which is under 18/1/2013 circular, which also says within 21 days the senior officer shall take action, and it shall be intimated to the subordinate officer. So all these circulars will have to quote. And the other important aspect is we need to prosecute anti-corruption officers too. Now what happens is when the accused are very strong and powerful, the police plays mischief. What does they do? The AOW, when you file a complaint to AOW, the AOW just forwards the complaint to anti-corruption, stating that इसमें भाई public servant है, आप इनको prosecute करो. एंटी करप्शन क्या करती है, बोलता है ये आईपीसी में है, आप उसको प्रोसिक्यूट करो. ऐसे करके मेरा 3 बार मेरे बारे में हुआ, मैंने एओडब्ल्यू और एंटी करप्शन दोनों को खिलाफ मैंने प्रोसिक्यूशन किया. So we have to be very strong enough. Our police officers, not all, some who are involved should be shown a lesson that you are not above law. एंड इसीलिए ऐसे ऑफिसर्स को खिलाफ हमको स्ट्रिंजेंट एक्शन लेना ही है, और उसके लिए हम हमारे पास जो भी फॉर्मेट्स है, जो भी है, वी विल शेयर विद यू. आप डरिए मत. आप डरेंगे तो पुलिस ऑफिसर आपको और डराएगा. आपके खिलाफ वो कुछ भी नहीं कर सकता. अगर आपने, आपका 2 नंबर का धंधा नहीं है और आपने कुछ गलत काम नहीं किया है, तो आपके खिलाफ केस करना इतना इजी नहीं है आज के जमाने में. हाँ, 1 साल 2 साल पहले बराबर था, मगर जब आज हमारे जो एसोसिएशन है, हमारे जो इंस्टीट्यूशन सब एक साथ में आ रहे हैं, इसका डर पुलिसों को भी है कि ये साथ में आएंगे तो हमको भारी पड़ेंगे. उसमें कुछ अपवाद हो सकते हैं, मगर हम साथ में रहेंगे तो पुलिस को इतना इजी नहीं होगा.
Wonderful, Kamlakar sir. I mean, you, Kamlakar sir, you and Dhumaskar ji, Nasir ji, and KV Jarrah, and there are, couple of other people, we consider you as.
Dhumaskar साहब मेरा गुरु है.
Yeah, we correct. हम आपको role model consider करते हैं. So and you have been sharing all your documents, very freely with everyone, so that people can use it for better governance and accountability and transparency.
Yes.
Yeah. So you're doing a wonderful job, sir.
Thank you, sir. Thank you.
And Gaurang sir has shared in the comment the links. So if anyone wishes to make use of the formats, then you can kindly follow the link and get the relevant documents accordingly.
Today itself, I have made a format about how to file complaint about junior officers, which I will share after making it perfectly.
Right. Kamlakar ji, thank you very much. आपने energy सब लोग को दे दिया आपने by your talk, by your explanation. Wonderful. Future में धुमस्कर जी के साथ में हम आपको future में will all hold a webinar by you also. Okay.
अभी सर मेरा बात करने का कैपेसिटी गया है, अभी मुझे बात करने को नहीं होता है ज्यादा.
ओ कमलाकर जी, आप ऐसे बोलोगे तो हमारा क्या होगा? हाँ, ऐसा बात मत कीजिए. हम लोग है सब साथ में. So फ्यूचर में हम आपका भी वेबिनार प्लान करेंगे, where similar to Dhumaskar ji, you also give your opinion on how to prosecute public servants. And this is a message for everyone. Just now I have put a link in the chat box. आप देखेंगे bit.ly का मैंने कोई लिंक भेजा है. कमलाकर जी के जो भी अब तक फॉर्मेट्स उसने हमें दिए हैं फॉर प्रोसिक्यूशन ऑफ पब्लिक सर्वेंट्स, वो हमने वहां पे फॉर्मेट्स डाले हैं. और भी जो 17/6/2016 का जो GR जो कमलाकर जी ने रेफर किया है, वो भी हम उनसे लेकर वहां पे अपलोड कर देंगे. और धुमस्कर जी, आपने जो ऑर्डर्स और सर्कुलर्स को रिफर किए हैं अपने पावर पॉइंट में. एडवोकेट धुमस्कर जी, आर यू लिसनिंग प्लीज? हाँ, you have referred to some orders and GRs in your PowerPoint. We request you to kindly, if you can, give us a soft copy of that. Okay, we'll upload it on the link which our admin Neeraj has uploaded on the chat box. Okay, like to.
और सर, hello, एक last, hello.
हाँ, बोलो.
देखिए, परसों मुझे क्लियरेंस ने एक हाईकोर्ट की जजमेंट दी है. And I want that everyone should know about that judgment, क्योंकि हम जब illegal constructions के बारे में या रास्ते पे encroachment के बारे में हम पुलिस के पास जाते हैं, तो पुलिस बोलता है आप म्युनिसिपैलिटी के पास जाओ, और वो टाइम पास करती है और हमको धक्का देती है. तो ये जजमेंट में अभी 2019 का जजमेंट है, जिसमें हाई कोर्ट ने कहा है कि फुटपाथ का एनक्रोचमेंट पुलिस का भी उनका हाथ है और उनका जरूरी है. अभी कमिश्नर ऑफ पुलिस ने उसका सर्कुलर भी निकाला है, बरवे साहब ने, कि पुलिस विल वेरीफाई एंड इमीडिएटली टेक एक्शन अगेंस्ट द एनक्रोचर्स ऑफ द फुटपाथ. अभी फॉर आपको ये बताना चाहता हूँ, हमारा डोगरी में अभी जो फर्नीचर वाले थे जिनकी दादागिरी थी, पूरा फुटपाथ तो जाम किया था उसने, 50% रास्ता भी जाम किया था. अभी बेचारे की ये हालत है, ऊपर के छप्पर भी उड़ गए हैं और उनको अभी रास्ते के फुटपाथ पे उन्होंने 10-10 फीट छोड़ दिया और हमारा फुटपाथ भी, रास्ता भी काफी खाली हो गया. only because we understand law, we know law, and we have to propagate to everyone कि भाई आप लड़ सकते हो. ये लॉ सबको मालूम नहीं, इसलिए जो गलत काम करते हैं हम पे दादागिरी करते हैं. लॉ बहुत स्ट्रांग है, सिर्फ हमको उसको पुलिस को दिखाना है और परसू करना है. तो अगर थोड़े ही दिन में आपको हम रास्ते पर से कैसे हटाने का उसके बारे में भी हम सब जानकारी दे देंगे. एंड बी वर्ड को हम पहले इसकी मिसाल बनाएंगे. जो बी वर्ड सबसे गंदी समझा जाता है बंबई में, उसको हम सबसे अच्छे बनाएंगे अगले 6-8 महीने में, और फिर हम बंबई को उसको मिसाल बना देंगे.
Wonderful.
Wonderful.
बोलिए.
Kamlakar ji, kindly go through the Bombay Police Act, section 25.
Bombay Police Act, section 25.
25, punishment for members of the subordinate rank of police officer, departmentally for neglect of duty, etc.
Okay. If at all you can provide me, because I don't have Police Act. If at all you can provide me, I'll go through.
Copy. So I'll take a picture and then I'll provide it to you.
Yeah, you send me my mail. I'll make it a document.
Of course, sir. Of course, I'll do that.
And 161 of the Police Act also. Same.
How much? What? Which act?
Police Act, Bombay Police Act.
Sir, which section?
That which says about civil suits also can be filed.
Sir, which section is he asking?
161.
161. Kamlakar, sir.
Yeah. Okay, 25 months. I think Dhumaskar sir has sent me this before, if I'm not mistaken. But I don't recollect where I have saved it.
Sir, we have a query from Hari, so I'm going to unmute him next. Hari ji, please go ahead.
Thank you, Dhumaskar ji, for a very beautiful session. And Kamlakar ji, also many thanks to you. आपने जो last time अभी last week में जो petition group में वो पूरे सारे format आपने दे दिया. In fact, you are doing a very good job for all of us, and so for making things accountable for this public servant. सर ये आप दोनों से ये सवाल है मेरा. सर ये 154(3) में जब हम DCP को लिखते हैं, even though it is a cognizable offense, and we keep reminding, he still doesn't reply or still doesn't take cognizance of this. Because when we go to police station, they dilute the offense. You know, वो छोटे sections लिखता है, which is not with strong punishment. So dilute भी करता है, and when we give this with evidence कि ये dilute कर रहे हैं evidence, 154(3) में हम DCP को भी लिखते हैं, repeated reminder to police वो लोग कोई act नहीं करते हैं. So when he is not acting, which is duty bound to act on a cognizable offense, so can't we also put DCP in dock for this?
Okay.
We can't be 160 के लिए under हम DCP को भी. Yes, with this I rest my question. Thank you. बोलिए sir.
Hello.
हाँ जी बोलिए.
हाँ कौन धुमस्कर जी बात करते तो वो बात करने दो. No problem.
Dhumaskar ji, would you like to answer his query?
No, I have not heard the query because the audio was not. Please tell me what is the query. First.
So under CRPC 154(3), the concerned DCPs are not passing orders. Yeah. Kamlakar sir, were you able to आपको समझ में आया उनका query?
अच्छा, see, I have told you from before, do not expect the police to do anything good. If you go with an intention that they will do good, you will be a total frustrated person. You go with this thing that you have to complete the legal formalities and you have to attack them. You have to go with that frame of mind. If you go with the frame of mind that the police is going to help you, you will be an utter frustrated person. So be prepared for a fight with the police. So if at all they do it, fine. If at all they don't do it, you have your way. You are ready, mentally prepared to fight. So as soon as you file an application before the police and 154(3), simultaneously you make an application before the CP, Governor, Chief Minister for prosecution of the IO, Senior PI, DCP. Make an application at that point itself. It will take 3 months. And during these 3 months, you go on continuously reminding them. Now, this reminder is a blessing in disguise for you, because the defense taken normally by the public servant is that they have done something in good faith and they were very busy and therefore they could not do all those things. But when there is a continuous reminder on your part, they are defense of acting in good faith is demolished, because if even after specific and several reminders, you cannot claim to be doing or acting in good faith. So these 3 months you should use to continuously remind them that they are doing wrong things. They are committing an offense under 166A. From your third or fourth letter of reminder, you should make it very clear that all the officers are committing an offense under 166A and therefore they should immediately register an FIR. You make it clear in every of your letters so that their defense is absolutely demolished and they have got no face before the court.
No, one second, Kamlakar ji, can you hear me?
Yes.
Now, 166A you are referring to.
166A and B.
166A and B. This is relating to the
Registration of FIR.
no, 166A.
Yeah.
Sir, it's the same section which we discussed earlier. The public servant disobeying direction under law.
That is pertaining to the basically women, no? Offensive.
1 minute, I'll just.
166A and B, both are.
See, 166A subsection B in 166A subsection B.
No, correct, but that is basically the amendment has been done.
Sorry, I can't hear you.
After Nirbhaya case, Nirbhaya, that is what I said. After Nirbhaya case, the amendment was done, but this is pertaining to basically only those particular sections.
No, I can't see. I'll just read it.
Sir, Kamlakar sir, Dhumaskar sir is saying that some amendment has been done after the Nirbhaya case, and it pertains only to that section. But Dhumaskar sir, that comes under subsection C of 166A. What Kamlakar sir is referring to is 166A subsection B, which says that knowingly disobeys. If any public servant knowingly disobeys to the prejudice of any person, any other direction of the law regulating the manner in which he shall conduct such investigation.
Because all A, B, C are independent, or. It is not and. But I would prefer that every person should every person should file an application for prosecution for sanction. Be safe, because the court is not with us. Court is 99% against us. They will find out ways and means not to do. And secondly, if at all you have made no application for sanction, they will just throw you out on that grounds itself, and you will be wasting much more time. And otherwise, also to complete these formalities, you will need 2 or 3 months. So by that time, you also make an application. Don't take a risk of that law. Unfortunately, it is very much difficult for us to implement law, in spite of the law being in our favor at every point of time. Even if we show law in RTI, the police has to give the information to the complainant. At every point they say investigation chalu hai, jabki there is a DG circular of 2012 that the complainant should get the information. If at all you don't have, I will provide those circular also. Day before yesterday, I argued a matter for my brother at Thane, but that lady has given a different order. So we need to prosecute such ladies, such police officers who are knowingly doing so.
Sir, this lady you speaking of, was she a judge or a police officer?
So she is a DCP.
Okay.
Additional SP.
And sir, in order to prosecute someone under 166A, what is the first step? I mean, is it under 154(1) directly to the SHO or directly to the court?
For everything, you go for 154(1), 154(3), and then go for, because you have to exhaust the remedies.
Correct.
Before you go before the court, you have to exhaust the remedies. Otherwise, the court will say you have not completed the law point, and then you are coming before your motives are not correct. You want to harass people. So you have to go there as if you are a victim after exhausting all the remedies.
Kamlakarji, about 166A, I will give you feedback or to all the members also. Because in my opinion, I have a slightly different. If you interpret it in
Yeah, I'm not not able to hear you, sir.
166,
166A subsection B.
subsection B with reference to basically you have to see that what was the bill which was when it was introduced also, and if you plainly interpret it that way, also it can, then there is already provision there. No, 154 there is already the provision is there. It is obeyed. But 166 provision is there. No, already disobeying.
Yeah.
The 47
Yeah,
disobeying.
but 166A subsection B will provide you with an assistance of no sanction required. But we should not take that risk of this thing. We should go for an application. So as you rightly said, whether it is A, B, or C, if at all we are going with a sanction, then it does not matter to us.
Yeah. Correct.
So I'll
Neeraj, there is a query someone has put up over there and raised hands also. Just check.
yes, sir. Manoj Kamra. I have unmuted.
Yes, sir. Yes, sir. In my case, ACB has filed FIR and it was ready to file the challan. It was ready to submit the challan in the ACB court. But the other parties, accused parties, managed to get stay, ex party stay, without making ACB as well as complainant to be party. And I have actually read in one ruling from the Supreme Court that such ex parte stay need to be extended by speaking order within 6 months. Is it true, sir? Ex parte stay order cannot be indefinite.
I can't hear what you. Can you tell me what is saying?
Pardon, sir?
What is the question?
Yeah, sir. I'll repeat it. What should be done in case of ex parte stay by High Court directing ACB not to submit challan without making ACB and complainant as a party in such stay?
Yeah.
Sir, that is the question.
So that is the stay.
Yeah, ex parte stay by High Court.
So that has to be obeyed, no?
Correct. So I believe that would fall under contempt of court, if I'm not mistaken.
Correct. The police officer will not go and he will commit a contempt of the High Court, no?
Correct. So Manoj basically needs your opinion on what can be done in such a situation.
You have to move the for vacating it. Okay. You want the charge sheet to be filed, no?
So the stay has been given by directing by the High Court, which directs the Anti-Corruption Bureau not to submit challan, not to submit the charge sheet without making the Anti-Corruption Bureau and the complainant as a party in such stay. Yeah.
No, whatever the order has to be, order can be violated.
So in such case, what can be done? That is.
You have to move the High Court only, no? Again.
You have to move the court. You have to move the court and say that we are objecting this thing and get it on board and argue the matter on merits.
Correct. Because the other authorities will not intervene. You cannot do it because it's a direction of the court. Whether it is the right or wrong order, you have to obey. You have no choice.
So ये सुप्रीम कोर्ट का जो ऑर्डर था 5 साल
तो वही दिखा के आप वापस उसको बोर्ड पे लाइए और बोर्ड पे लाके मेरिट पे आर्गुमेंट कीजिए.
अच्छा, ऐसा कुछ नहीं है. अच्छा, ये इस तरह का ये क्या है ऑर्डर पर इंक्वायरी नहीं है ये अगेंस्ट, मतलब एक तरह से पर इंक्वायरी कहते हैं ऑर्डर इस तरह का विदाउट मेकिंग पार्टी ACB टू बी पार्टी एंड डायरेक्टिंग इट नॉट टू सबमिट द चालान. सच ऑर्डर लीगली
तो हो चुका है, उसको अभी चैलेंज करो. वो आप ये पूछ नहीं सकते कि कोर्ट ने कैसा ऑर्डर पास किया. दैट्स ऑल. दिस इज अनफॉर्चुनेटली इट इज द फैक्ट ऑफ लाइफ.
यस सर.
कमरा जी, अगर वो ऑर्डर जो है वो अगर कंसर्न्ड ऑफिशियल्स इंप्लीमेंट नहीं करते तो फिर वो कंटेम्प्ट ऑफ कोर्ट में आता है. ठीक है. आपका अगर लॉयर है तो आप उनके साथ में डिस्कस कर सकते हो. Right. There's an appeal procedure as well. But there's an appeal procedure, right, sir?
But you cannot disobey the order.
Correct.
Okay.
So
If the
disobey
Supreme Court
करते हैं
gives the
तो
order, then that will different matter.
No, I mean to say this ex parte stay is being extended indefinitely for the last 3 years.
It is the order of the court. Whether ex parte, you can make a submission there saying that there is a fraud claim. And then
Okay.
make the court to make the submissions, and accordingly there has to be a order either from the clarification from that same court or vacating from the same court or from the superior court.
So you mean to say high courts are not bound to obey Supreme Court rulings that to extend any ex parte order they have to.
So order is passed by whom? Order is passed by whom?
Oh, just forget about that order. Now my submission is that once they have passed ex parte stay order, and after 6 months, the Supreme Court was when the bench has the order given direction.
You make an application for vacating it. You go and make an application immediately,
Oh,
and you fight it on merits.
I think you have not gone through that the Supreme Court order. The Supreme Court, Mr. Adarsh Goyal, Justice bench that has ordered that.
It will automatically be vacated. It is automatically be vacated. But in practice, it will not be possible. In practice, we have to still go a long way. There are many things which a law is different and practice is different.
After 6 months, yes, after 6 months without speaking order, this will automatically get vacated.
Yeah.
So there is no need. There is no need to comply with High Court.
You are referring about the stay or if it is granted automatically vacated. Correct. That is what you are saying, no?
Yes, sir.
That is in respect of that also can be. If they vacated, then it will amount to a contempt of the Supreme Court order. Correct.
That's my request. What to do now? Actually, this is being violated several times.
Listen. Your query is now there was a direction by the High Court not to file a charge sheet without making those persons as a party. Correct.
Yes, sir.
And then there is a Supreme Court decision. You can say that if the stay is any granted of the criminal proceeding or civil proceeding within 6 days, it will stand vacated. Correct.
Yes, sir.
I think that decision now there is no stay now though, so therefore the IY has to file a charge sheet.
There is still continuing stay for the last 3 years. It is continuously being extended.
And then move the High Court saying that is a contempt of the Supreme Court order.
So can we directly go to Supreme Court in such?
There is a Supreme Court order generally now. There is a vacation. Now you move the High Court saying there is a Supreme Court order and there is no stay. Still it is a stay.
Okay, sir. Thank you, sir.
It will amount to contempt of the Supreme Court order.
Yes, sir. Thank you.
Right. Manoj Kamraji, see, Advocate Dhumaskar ji said that a Supreme Court order says that such an indefinite stay cannot remain on this thing. So
yes,
do take that order from Dhumaskar ji. You have his contact number and the email ID. Okay, do contact him. Take that Supreme Court order and put it in your appeal, or whatever. Okay, so that's what it is. Now, are there any more queries over here? Anyone else has raised the hand? Neeraj?
No, sir, I am not able to see any more hands.
All right. Degree. Suppose Dhumaskar ji, if there's a degree for other than LLB, okay, who activists can be given for knowing intricacies of law and whatever, Kamlakar ji will be the first person to get that, isn't it? Kamlakar ji, you should be given that degree. Okay.
क्या
कॉलेज में पढ़े बगैर अगर लॉ जानता है कोई तो उसको डिग्री मिलना चाहिए कुछ, तो आप पहले हकदार है उसके.
नहीं मुझे खाली 10-20 I know only 10 or 20 sections was law is very vast.
नहीं, लॉ इज वास्ट इंडीड. दुबस्कर जी भी कहेंगे जरूर, लेकिन लोग LLB LLM करके जो भी डिग्री ले लेते हैं, लेकिन अगर एक्टिविस्ट को मिलना चाहिए स्टडी करके अपने हिसाब से अपने केस में एक्सपर्ट बन जाते हैं तो आप पहले हकदार है उसके. ओके.
Thank you for your
Oh, yes.
compliments.
I endorse.
और सेकेंडली क्या है कि आप मैं फिर से दोहराना चाहता हूँ कि ये सब क्रेडिट जाते हैं गौरंग वोरा को, क्योंकि 2011 में मैं जेल में गया था, तभी यही गौरंग वोरा बारिश में वसई तक आए थे अकेले, 3-4 लोगों के साथ, कृष्णराव और 2-3 मैं नाम भूल गया हूँ. तो इन लोगों ने मुझे मोटिवेट किया, इसलिए मैं आज यहाँ पहुंचा हूँ. उस टाइम पे अगर ये मोटिवेट नहीं करते तो मैं टिपिकल मेरा चाय पे दुकान पे जाके बैठता, चुपचाप चाय बेचते रहता. तो दिस इज ऑल the love and support from all of you. It is not my individual success and I thank you all, क्योंकि आज मुझे आप लोग किसी न किसी तरह से हेल्प करते रहते हैं. मैं खाली एक क्वेरी डाला तो मुझे हर जगह से सपोर्ट आ जाता है, इंफॉर्मेशन मिल जाता है, जिसकी वजह से मैं काफी अच्छी तरह से लड़ पाता हूँ. So therefore it is all our joint efforts and ये आप सबका जीत है, मेरा अकेले का जीत नहीं. Thank you so
अच्छी
much.
बात है कमलाकर जी, आपकी ऑनेस्टी और आपकी जो अन्याय के खिलाफ लड़ाई थी, इसके लिए हम सब साथ में हैं, उसके साथ में. इवन एट दैट पॉइंट ऑफ टाइम आल्सो वी फेल्ट दैट such good activists, such good persons should be supported. और वही हमारा प्रयास आज भी चालू है पेटिशन ग्रुप का, कि कहीं भी कहाँ भी ये जो अन्याय के खिलाफ हम जो नागरिक लड़ते हैं, उसको हम हो सके वैसे हम उसको सपोर्ट करें, जो भी रीत से. मॉरल, कम से कम मॉरल सपोर्ट, फोन करके भी अब बोल दे कि भाई ओके, वी आर विथ यू, डू योर बेस्ट, और वी फुल्ली सपोर्ट यू. तो और अन्य रीत से भी हम उनको सपोर्ट कर सकते हैं तो करते हैं. धुमस्कर जी और नाजिर जी और प्रशांत पांडे जी, हम सभी लोग हो सके वैसे लीगल हेल्प हो, फाइनेंशियल हेल्प हो, जैसे भी हम अपने साथी नागरिकों को हम सपोर्ट करते हैं. वही तो अपना पेटिशन ग्रुप का ध्येय है कि भाई लेट्स एम्पावर मोर एंड मोर पीपल, लेट्स मेक एवरीवन मोर aware about the law, aware about their environment, about misgovernance by the public servants and public representatives. So this is to inform all. That's what our intentions are or objectives are of this petition group. If you wish to also be a part of our group, I have put myself and our admin Mr. Neeraj Patat has put the link over there in the chat box. Please see the chat box. We have put the link. I'll put it once again in the chat box. Kindly copy down the link. It's on our website also, and the same thing is over here. Join Signal Group. If you can see the petitiongroup.com, join Signal Group. So kindly fill up the form over there. You can, once we approve of our group members approve of your application, we'll definitely add you in our Signal Group, and you can be a part of this process. Read the objectives thoroughly in the group, and if you agree with it, we'll join you definitely. So. Dhumaskar ji, there are several, as I was saying earlier, orders and circulars that you have stated in your mention in your PowerPoint. If you can give it to us, we have created the link which Neeraj has put it in the chat box.
These are those judgments, circulars, etc. In China will be any circulars, etc. But judgments, I can give the judgments.
All right. So whatever you can, whatever you have mentioned.
The Supreme Court has regard that the prosecute the persons who are conducted a faulty investigation and innocently made the people, and that also is. I will forward it. I will forward it to the.
Please do that, please. Myself or Neeraj, if you can, or Clarence, you can.
Gaurav ji, one more I would like to explain. Tell people कि अपना जो मुंबा देवी प्रजा फोरम है, फाउंडेशन है, our group petition is concentrating on educating the people, and Mumbai Devi Praja Forum is working on the ground level against illegal encroachment and roads and footpath and all those things. So we should also motivate our members to fight against the illegal encroachment on roads and footpath also, because that is the greatest hindrance now, which is causing us harassment and as well as agony. Because for half an hour travel, we have to wait for about 2 hours, 1.5 hours because of encroachment and all those things. So we should now increase our vision to roads, footpath, encroachment also, which can send a right signal to all public authorities that the citizens are being aware. Now days are not far that they will have to be afraid of us rather than we being afraid of them.
Indeed, Kamlakar-ji. Yeah, good you mentioned that, Kamlakar-ji. This is to inform all, all our petition group members also and everyone else who has joined today that, somewhere or the other, we have to work on the ground too, rather than, only, educating and empowering our fellow citizens. So this Mumbai Devi Praja Foundation, who are mainly concentrating on the B ward and the C ward of Mumbai, okay, they are fighting for that big problem that everyone must be aware when you pass by that Dongri, Mumbai Devi, Masgaon areas. There's tremendous encroachment on the footpath and the roads. So they are striving for removal of this encroachment. And, let's be a part of this. In future, they'll be holding a big awareness march over there, awareness walk over there. In
Mostly
whatever way
on
we
5th
can
of August.
support.
Mostly on 5th of August.
5th of August. Okay. Tentatively 5th of August, they have decided to have a awareness walk over there with regular permissions and everything. So let's be a part of this. Let's support them in whichever way possible. Similarly, whenever your area requires some, assistance and support from the fellow activists for whatever issue, it could not be not only encroachment, it could be some unauthorized constructions or other civic problems or traffic problems. We all can come together to, support you all in getting that problem addressed, the officers penalized, etc. So kindly let's all, join hands together and come together. You have any feedback to give, everyone can visit our website www.petitiongroup.com. if you wish to join, there's a link for that. Join PG Signal Group. You can come on that. I've put the link also in the chat box. You may go through that. Okay. So
group petition is a brain, and Mumbai Devi is is hand and legs. So let us coordinate.
Yes.
Let us coordinate, and we assure you that by next 5 years, Mumbai will be at least 20 to 30% better than what it is today.
Amlaka sir, I have emailed you the copy of Bombay Police Act 1991 as a PDF.
Right.
Yes,
right.
indeed. Yes, Kamlakarji, indeed. I fully agree with you. Let's all, do our bit just by, cursing those people, as they say, let's light a candle rather than cursing the darkness.
Yes,
so similarly, so let's all do our bit in whichever way possible. There are people who are fighting. It's not that I akela kya kar sakta hu. No, sir. There are people, there are experts who are there to guide us, be with us in whichever way possible. So let's join hands. Let's make our movement stronger and make our Mumbai, make our country stronger. All right. So Dhumaskar ji will require those whatever material you can give. We'll upload it on our website. Even the PowerPoint which you have given today has been uploaded on our website and is there on the link provided by Neeraj ji in the chat box. So everyone who wishes to access Advocate Dhumaskar ji's PowerPoint, may kindly go to the link and the path given here. The link has been given by Neeraj just now, and the path also to the thing, to the cloud link, cloud this thing, folder on the cloud. All right. So Dhumaskar ji, this matters in future. We can always, and there are many. I've seen just now. Okay, there are many advocates on our group who are, who advocates on this webinar today, and I request all such advocates over here, experts on the group over here on this Zoom webinar today, to kindly come together, kindly join hands with us, because we all activists, most of us people are fighting for better governance, for reduction of corruption, for making our public servants and public representatives perform their duty as per law in letter and spirit. So kindly let's join hands. We require the help of our legal experts and the advocates on the group, and fellow activists also in every way, because we all have our strengths and weaknesses. Let's pull in our strengths. Let's do our bit, okay, to make this world a better place to live in. So thank you very much, everyone. Let's meet again in the future. If you all have any topic for us to convene a webinar upon, any legal, anything that improves our governance, empowers our fellow citizens, then kindly revert back to us on our website petitiongroup.com. There's a feedback form. Contact us. You can come over there, write whatever you wish to say, whatever topic you want us to conduct a webinar upon. And if you know of any expert who can very well explain on any issue, it could be environment, it could be law, it could be corruption, it could be civic issues, traffic issues, whatever. So whatever you feel needs to be you know, empowered, which will help in empowering our fellow citizens, kindly put in your thoughts over there. We'll definitely apply our mind and do the needful as the days go on. All right. So thank you very much. Dhumaskarji, thank you so much for giving so much time. Okay.
My
It was a
my
pleasure
salute to
listen you.
Dhumaskarji. My salute to him.
Yes, yes, indeed. Dhumaskarji, maybe, you know, next time you can put a earphone, earphone over here and, you know, speak through the microphone so that, you know, we'll be able to hear you more clearly the next time. Bolo ji. Dhumaskarji, you are saying something.
I suggest, Boraji, I suggest another topic. As you can say, how to prosecute a minister.
Very
All right.
good.
Sure.
Very good.
Sure. And you can suggest a
How
speaker
to
also on that, if
prosecute
possible.
Minister, how to prosecute a corporator.
Right. Right. Public servants, all the three public servants.
Yes.
Sorry, public representatives.
Specific-
Corporator, MLA, MPs.
Or prosecute those PIOs who are not furnishing information also.
Perfect. That is the need of the hour. That is the need of the hour now.
Beyond the scope of, we need to examine various aspects of it also. RTI.
Indeed, Dhumaskarji, fully agree with you. We need to
Gaurav,
prosecute the.
next topic you can keep how to prosecute PIO and first appellate authorities who are
Yes.
willfully not giving information. That will be the better topic.
Sure. Definitely. So, public information officer and first appellate authorities who don't, adhere to the law, who do not, excuse me, do not provide information malafidely, deliberately, and malafidely, indeed needs to be prosecuted.
Correct.
So, let's have a webinar on that. We'll plan that accordingly, appropriate speaker and the, matter on that. And as Dhumaskarji also suggested, the three representatives, MLA, corporator, MLA, and MP, those three people also need to be prosecuted for their mischief, for their, acts of, violation of the law or non-performance of their duties malafidely. So let's keep a webinar on that too. We'll discuss that, Dhumaskarji, as after this webinar.
Why I'm saying that? Because only the president and the governor is exempted from criminal and civil liability.
All right.
Nobody is above law, the rest of them.
Fantastic. Yes, indeed.
I'm not saying if they are committing wrong, and we see the so many instances that people can't afford to tackle this group or whichever group voluntarily comes forward, that will be great help to the people.
All right. Yes. Point taken, Dhumaskarji. Definitely, excellent ideas we have received today on, future webinars on, matter that will empower our fellow activists and concerned citizens of our country. So we'll definitely apply our mind as in the next, coming days. So thank you very much, everyone. Thank you, Dhumaskarji, once again for giving us the time and your, imparting knowledge to us all concerned citizens on the webinar. And let's meet again. And of course, my special thanks to our admin, Mr. Neeraj Patat, who has been, passed over almost all our webinars have been conducted by him. So thank you so much, Neerajji and Kamlakarji and everyone else on this webinar today. Let's meet again in the coming days. Thank you very much, everyone. Thank you.
Good night.
Good night.